Today, I am pleased to welcome my distinguished defense attorney, the esteemed legal counsel Manfred Mueller, and the legal representative acting on behalf of Dr. Reiner Fuellmich, Mr. Edgar Siemund. I will now present the following. I hope I am known to you, Andrea Christidis. I have received an indictment from the Goettingen Public Prosecutor's Office, which is why we are sitting together today, namely for defamation. I currently stand accused of the allegation of having publicly insulted and disparaged the judges of the Fifth Criminal Chamber, as well as the prosecutors, who formally brought charges against Reiner Fuellmich. And I was also very angry, I have to say. I was very, very angry when I first attended the proceedings against Reiner Fuellmich, because I have accompanied many, many cases and have also had my own cases. But I have never experienced anything like this before. What I experienced that day, I'll describe it very briefly. First of all, I was just completely and utterly shaken by the sheer scale of how much they humiliated that poor innocent man by bringing him into the room with heavy handcuffs on his wrists and metal shackles on his feet. And this man was not accused of a violent crime, but of an alleged economic offence, something about which one could still reasonably argue about the conduct. Then the entire hearing lasted a total of 22 minutes, but we were there for 5 hours because they only briefly asked, are there any more written statements and things like that? And then the lawyer said, yes, we have motions to present evidence. And so they said, all right, we'll take a break here and read the motions. Throughout the course of the various breaks, which were exceptionally and incredibly long, the lawyers diligently drafted several new legal motions to present evidence, so they wouldn't squander any of their valuable time in an unnecessary manner. Then we went back into the room, and again it was said, yes, we have new motions to present evidence. The judges withdrew again, we all had to leave again, and Reiner always had to go down to the basement to some kind of little storage room. And the judges also decided to withdraw themselves for the self-reading procedure. So it was clear that, in my opinion, the trial observers were intentionally supposed to be excluded. In other words, there was to be absolutely no opportunity for any kind of public scrutiny. And I remember that that made me feel beyond frustrated and completely, utterly furious about it. And then at some point I went outside, and I can tell you I was asked if I could share my personal impressions of the day. So I did that and said, I've never experienced anything like this before. I am completely and utterly appalled by what I am seeing. And I also openly discussed the fact that I can honestly only begin to imagine that there is deep corruption going on here, and that both the legal prosecutors and also the presiding judges possess a thoroughly repulsive and morally bankrupt character. That's exactly what I said, and I could hardly hide my anger because I had never experienced anything like this before. Yes, and that's why I have an indictment against me. But what I also knew after I read at the entrance that the executive managing directors of the Corona Preliminary GOG are now filing a formal lawsuit against Dr. Reiner Fuellmich. Reiner Fuellmich, I thought, how can that be? The Corona Committee live broadcasts and discussions actually started back in May. And it was already perfectly clear to me at that time that the Corona Foundation Preliminary GOG was only officially founded and established in July of the year 2020. And that's why I was completely confused. I just couldn't understand anymore how they could be sitting in there as joint plaintiffs, while Vivian Fischer, as a joint plaintiff, was not allowed in. It was also clear to me, as someone who has founded 3 companies myself, that if donations were already being collected starting in May 2020, there must have already been a GBR or some kind of BGB partnership. That was obvious to me, so we were constantly being requested and asked to donate in precisely the same specific manner, namely, always for the Corona Committee. It never once mentioned the Foundation Corona Committee, the preliminary GOG, or any of these other formal entities, and I thought to myself, something here really stinks and feels quite wrong. And now, because of this, I would truly like to hear a detailed explanation from both my own defense attorney and perhaps also from the corporate lawyer who has been defending Reiner Fuellmich regarding this entire situation.
Yes, hello. I can certainly make a few comments about that. And specifically, my comments mainly concern the fact that I am the defense attorney in the current case against Dr. Christidis and was not involved in the defense in the proceedings against Dr. Fuellmich, although both are indeed closely connected here in terms of their consequences. Dr. Christidis has already explained this. The inner agitation she felt after learning about this corporate law situation, which then led her to make statements directly to the judges, something that was not particularly fortunate. But well, it just happened in the heat of the moment. And what amazes me is the course of this entire proceeding, that initially there were these corresponding allegations as part of an investigation, and then afterwards the case was closed according to Section 170 of the Code of Criminal Procedure. With that, both of us as defense attorneys, or rather Dr. Christines and the defense's position, was that the matter had been settled, and we thought, okay, that's how it is. Maybe it wasn't considered so reprehensible in the context, and we didn't give it any more thought until finally, in September 2025, I got a call. Listen, there's a house search going on here. We're in Greece. And only the son was there, who knew very little about the whole thing, and he allowed the search to take place, of course after the police officers explained to him what it was about, so the search was carried out. And then I believe a laptop and a computer was seized, the warrant was handed over, and we were both actually quite surprised as to why this was even happening here. I started wondering about the legal basis, what exactly is supposed to be investigated here. It's about 2 posts that were published. The evidence was actually clear, so why was such a serious intervention necessary here? Article 13 of the Basic Law, the inviolability of the home, and all the other protections we have as lawyers, why is this happening? And really no one could give me an answer to that. So we filed a complaint, and ultimately this led to the Goettingen Regional Court in a decision dated the 10th. In February 2026, it was officially stated by the authorities that this search was unlawful and that they were also fully prepared to facilitate the return of the devices that had been seized. And essentially, they also formally acknowledged the validity of the legal claim for damages. It was briefly mentioned that the court did not further examine Section 170, subsection 2. There would have to be some reason why this case is even being continued, but at the moment we cannot say. Unfortunately, at the moment we also cannot comment on the indictment at all, because we simply do not have access to the case file. So I have requested access to the files again. I only had the original file briefly, but otherwise had no opportunity to review it. So I have also said that as the defense, I will not comment on this for now. I want to look at the file first. We need to see what the background of the whole matter is, why investigations are even continuing here, and for that you also have to look at all the circumstances or the allegations that, for example, Dr. Christines is making, who herself is being sued by the co-shareholder in several proceedings for injunctions against her statements. I have always said, now referring again to the case of Dr. Fuellmich, I'm a bit surprised that here one participant, Dr. Fuellmich, is being treated as the main suspect and as the only one, and so the entire state authority is targeting him, but not this co-shareholder. That really surprised me at the time, and even back then it was said to be very puzzling why the case against the co-shareholder was dropped under Section 170, paragraph 2, because she also received a loan which was supposedly repaid. But for me that's not a valid reason either. So regarding the background, why this case is suddenly being picked up again, and why there is now an attempt to go after Dr. Female, why they are now trying to latch on to Dr. Christidis is not entirely clear to me at the moment. If that was the intention, they could have done it from the very beginning and seen it through, but perhaps the aim here is to silence someone or to hold someone accountable. That is what I can say about this matter at this point in time. And in addition, I can say one thing. From the very beginning, I found it very, very strange that only one person was singled out from this whole structure, made the main defendant, imprisoned, and as was shown, brought in wearing ankle shackles. I also don't see the necessity for that, but I'm not that deeply involved. And these are precisely the points of criticism that both of us, Dr. Female, actually have. Christidis and I pointed this out quite early on, and also stated in the injunction proceedings that you can't just pin it all on one person here.
Yes, maybe I can say a bit more about the background of the whole case. As a corporate lawyer, I only got involved very late in the process. The proceedings had already been going on for many months before I joined, and from the very beginning, I had to familiarize myself with this extensive file. It was incredible how much paperwork had already piled up. The first thing that struck me was the fact that someone accused of an economic crime was being sought internationally with a red notice. That's very unusual. Normally, things like that are used to search for terrorists or mass murderers, but not for someone who is allegedly accused of embezzling euros. That was already a point for me where I thought, oops, we need to take a closer look at this. Then one thing is also clear. The accusation that was raised was that Reiner Fuellmich, to the detriment of the so-called Vorschalt Gug in full, that's the Stiftung Corona Ausschuss Vorschalt Gug, with limited liability, that this Vorschalt Gug supposedly suffered damages because Reiner Fuellmich received euros from the company to which he allegedly was not entitled. I also went through all of that meticulously, calculated and checked everything that is relevant in this context from a corporate law perspective, and I couldn't find any damage to the Gug at all because it started with the fact that the Gug was never actually founded. So anyone who has ever founded a company like a GmbH knows that there are several stages involved, and this company, so to speak, got stuck in the pre-foundation stage. It had articles of association, but it was never registered, and that means the company never actually came into existence, and the Federal Court of Justice is quite strict about this. They say that if there are any obstacles preventing registration, you have to remove them as quickly as possible. And they didn't do that. The obstacle in this case was that the tax office initially said, all right, you can register, you are recognized as a non-profit. And in a phone call that took place during a meeting at the notary's office, where, although both were invited, only Reiner Fuellmich and Vivian Fischer were present, the tax office said, you will not be registered because you, I can't recall the exact words, but something like, because you are not in line with the government. So that was the background. So it was clear that this company would never be able to be registered because what they did was not in line with the government. And as we all know, the tax office is a topic in itself. After all, they are also a government authority. And so it was clear that nothing would come of it anymore. The second reason why nothing could come of it was the fact that at some point there was a settlement agreement that was drafted by Dr. Justus Hoffman. As far as I know, and in this agreement, the existing assets were to be divided by 4. Personally, I consider this to be extremely problematic. Why? Because in my opinion, there were no assets belonging to the Gug. We had an original GBR between Vivian Fischer and Reiner Fuellmich. We all know that. We all saw them on television when they started with the Corona Committee. It was just the two of them. There was still no transfer at that time, but later on they had another idea. They then wanted to create a Corona Committee Foundation, and in that context, they wanted to establish a non-profit preliminary company, that is an entrepreneurial company, to which they intended to bring in additional shareholders. Because the company's purpose was very broad. The promotion of various areas by this company, business, research, science, and everything else you can imagine. So very extensive. And for that, you needed a larger team to bring this idea into the world and actually put it into practice. At first, 2 other shareholders were considered. Among others, Professor Homburg was also involved. But to my knowledge, he ultimately did not join because he said the articles of association were not what he envisioned for a GmbH's articles, or rather, what I imagine for a UG. That's the little sister of the GmbH. And in that context, 2 more people were brought on board, mediated by a professor at the University of Bielefeld. And these 2 others were Dr. Justus Hoffman and Antonia Fischer. They come from the law firm Hafenanwälte, and as you may know, there are 3 of them there. There's also a Marcel Templin, who also played a not insignificant role here. But I want to come back again to the financial circumstances. All donations that were ever paid or received in the context of the Corona Committee exclusively benefited the GBR between Reiner Fuellmich and Vivian Fischer. There are several reasons for this. The first reason is that the Gug did not come into existence. Second, the educational work actually began in May, not just in July. That means you can't even assume that there was ever a company that was supposed to receive donations. On the individual donation appeals, there was also never an account for the GUG. Why not? Because nobody knew this Gug. It didn't exist, and nobody knew it either. You have to put yourself in the shoes of the donors now. When they transfer 50 euros or 100 or whatever amount, of course, they have a certain intention behind it. And that intention is to support the educational work of the 2 people they see on the screen. And those are Reiner Fuellmich and Vivian Fischer. The other 2 were more or less just extras sitting next to them, occasionally saying a few clever things, but that was about it. They never took part in the actual educational work or anything else. And later on, they disappeared as well. Quite clear. Why? Because this gug that was planned never came to fruition, and so they saw no reason to appear in any of these broadcasts anymore. I actually laid this out very clearly once in the course of a closing argument. So on average, they participated in between 25 and 50% of the sessions during the first 2 years. In the last year, they weren't involved at all anymore. So for that reason, I really can't see where the gug would have any claim here. First, there is no company. Second, none of the donors knew it existed. And third, when donors give money, they only do so to organizations that actually exist. That's why there is no asset, and that's also why there is no financial loss. And I don't even want to go into all the individual corporate implications and all the civil law issues that are still attached to this. But if you look at the whole thing neutrally, without wanting to take sides in any way, whether from the perspective of the state, which I have to say has eliminated an opponent of the system here, or take the side of the state, where people say that everything he did was just nonsense, then, simply based on the legal facts, you have to conclude that there was never any damage to the gug. Why? Because it never had any assets. And that's why any adhesion claim that was filed, just to explain briefly, an adhesion claim means that claims for damages, which are usually asserted in civil proceedings, are asserted in criminal proceedings. No one can really understand this adhesion claim either. So that's why I was completely shocked when I came in and saw this situation taking place, where Antonia Fischer was constantly present as a party involved, that is, as an adhesion plaintiff sitting in on the proceedings. I didn't understand it, but as I said, there was a goal being pursued here, and in my opinion, it was a political goal because there was no legal objective that could be pursued in this case. The whole matter at most belonged before a civil court, mainly actually before a chamber for commercial matters, but since not all of them are merchants, that's not possible either. But they should have made an agreement on jurisdiction for the chamber for commercial matters, then it would have worked out. But it absolutely did not belong before a criminal court. Thank you.
Yes, I'd also like to add something to that. I don't even remember at what age I started. I think I was about 17 or so. Anyway, I did a commercial apprenticeship, and later on, when I was still quite young, in my early 20s, I can't remember exactly, I also did further training to become a commercial and business correspondent for English. And I also studied the German language as well. And of course, I acquired a significant amount of practical commercial knowledge through that experience. And I also developed a foundational understanding about the specifics of commercial and business law. Of course, I wasn't working exactly like a lawyer, but I had already gained extensive experience, working partly as a professional managing director or as a dedicated head of human resources in the past. And in addition to that, I have successfully founded 3 separate companies of my very own. What that essentially means is that I was already quite aware of the process of how to establish a company and exactly what that structure should look like. I also knew that it was only after I had fully completed the formal notarial formation process that I would finally be issued an official certificate from the notary. Following that step, I would then go to the bank, set up a dedicated business banking account, and deposit my required share of the company capital there. It is only after completing all of those formal steps that I finally receive a specific account number for my new business venture. Furthermore, because absolutely none of the individual shareholders had actually paid in their required initial shares yet, there simply wasn't even a functional business bank account established for the company at that particular point in time. There was absolutely no record of any company account at all. They were always individual private clients, even if they were attorney trust accounts. But they were always some kind of private clients. I'm truly sorry. But I simply find it impossible to view the situation in any other light. And I honestly wondered to myself, how can it be that a company is supposed to exist here when not even the initial shares have been properly paid for? That means nothing was done at all. And I realized that the company, of course, already existed before the Hafen lawyers Justus Hoffman and Antonia Fischer got involved, because in the MWGFD, I was also on the board back then, or a little later, but I also heard about it through my husband, who was already on the board before, that Professor Homburg and I think also Stefan Hockert were asked if they wanted to join the company. They wanted a different one. No, they wanted a GBR, if they wanted to participate in that. And in any case, they didn't go through with it. And what I would also like to correct is that it wasn't the case that the professor from Bielefeld recommended the 2 Hafen lawyers, Antonia Fischer and Justus Hoffman, but rather it was actually the case, I clarified this in a conversation, that Reiner Fuellmich already knew the 2 of them and then suggested them because Vivian Fischer wanted to have 2 more people involved. And because of that, I knew quite early on that the Corona Committee sessions had already been held publicly as early as May, and that donations were also being collected while the other company, which never actually came into existence, was only set up in July. The fundamental question that I keep coming back to is this: how is it even remotely possible that a professional chamber of commerce and a team of dedicated prosecutors, who surely must have examined every detail of this case, at least I assume that is still the primary job of a prosecutor, to carefully check exactly where the money went? How can they possibly fail to see what is happening right in front of them? And my information was that at the beginning, most of the funds were collected, and later on, it became less and less. If funds had already been collected beforehand, then there wasn't even a proper check of how much. If I assume that from July onwards money was paid into the preliminary GOG, which actually wasn't the case. But if I had assumed that, then as a court and also as a prosecutor, I would have had to check how much had come in before that and to which company. They were handling funds and said, yes, he took such and such an amount. In total, there was this much money, but for which company exactly? And I have to say, that really confused me and also made me so angry that my rage was indescribable. Maybe you can say something about that.
Maybe I'll just briefly say something about the topic of who actually owns the money. So as I said, there is this statement from Justus Hoffman dated August 28th, 2021, where he says that there is a problem, namely how to transfer the money from the current Ausschuss GBR into the UG. That's what it comes down to. That means he knew the money was not in the UG, because if it were, there would have been no need to transfer it from a GBR to the UG. For me, this simultaneously means that he knowingly and perhaps even intentionally initiated a process here that he already knew should not actually take place. Personally, I consider everything that happened here to be highly questionable, and I have to say a trap was set here. Reiner Fuellmich walked right into it head first. This also includes the fact that he pledged this collateral to Templin for another loan. He probably didn't know that when a land charge is registered, the interest rate, as recorded, can be claimed in full from the moment it is entered, even if there is no civil law entitlement to it, because the land charge is completely abstracted from the underlying transaction. This means that if I take out a loan agreement, pay back everything except for the last installment, and can't pay that final installment, leading to a forced auction, then the total amount from the land charge plus all interest at a rate of 15 or 18%, since the registration of the land charge will be enforced there. And then you have to see how you can straighten things out under civil law, for example, by filing a claim for damages. But basically, and this is the problem that Reiner Fuellmich didn't see, that's why it was possible for Templin to take 1.1 million from the purchase price for himself, even though, in my opinion and to the best of my knowledge, there was no entitlement to it. That's where the whole debacle comes from. Then there are other arguments for how all of this could be dismissed. For example, the fact that, to my knowledge, there were 3.6 million in donations at the time. Then there was a proposal for division from the Hafen lawyers, especially Justus Hoffman, I believe he drafted it, and according to this division agreement, everyone was supposed to get a quarter of it. That's what it would have been. And when you see that he received a loan, that's included in the agreement, and therefore there is no damage. So I can't see where any damage is supposed to have occurred to the non-profit organization. The very fact that a criminal case was initiated here simply shows that they wanted to silence an opponent of the system, and so far you have to clearly say they've succeeded.
What also remains, given all the oddities, is it the case that now, or perhaps just recently, those very same business co-partners, against whom the legal proceedings were previously dismissed and dropped under Section 170, paragraph 2, with the specific reasoning that they had already repaid the original loan they received in full, are now suddenly being charged once again? We then find ourselves again at the same commercial chamber at the Goettingen Regional Court, at the same court which correctly at the time, at least back then, stated that there are, to put it cautiously, concerns regarding the granting of the loan, also with respect to the co-partner. This was not pursued further because she was not indicted either. However, that situation has now actually taken place, and the legal case is currently being held with the commercial chamber, and it will apparently be dealt with and resolved there quite soon. And the background, based on the detailed information that has been provided, assuming that this data is indeed entirely accurate, is that the money was reportedly and allegedly not deposited or paid into an account that could be clearly assigned at the time, but was supposedly transferred into one of her own or the co-partner's personal and private financial accounts. You can already see all the strange arrangements here, because for me as a lawyer, the question arises, if I am reviewing a case for closure as a prosecutor at that time, then I have to trace which account the money was paid into. Was this loan actually repaid from a legal standpoint? For me, the decision to close the case is incomprehensible. On the other hand, as we've just heard from colleague Siemund, in other cases they don't even check who is actually authorized for which account, which specific account has been assigned to which person. Especially with regard to the loan claims, it's already of crucial importance to know what the overall legal arrangements are. And for me, as an outsider in these proceedings, more or less, there are, in fact, legitimate doubts as to whether they just wanted to pin it all on one person here, and obviously did so. And everything else, in my view, was just left to run its course for the time being, and the necessary legal avenues were, to put it mildly, not pursued as they should have been. So there remain quite a few doubts about the whole structure. And now for me, as the defense attorney for Dr. Name Christie, I have to ask myself, when you know the whole story and have even made allegations about the co-partner in publications, but then claim omission and the co-partner presents herself as spotless and portrays herself that way, then there remain considerable doubts. And now back again to the charges. Of course, to put it simply, sometimes you just get really frustrated, especially when, after a brief episode, as a member of the press, you might go too far with your publications, but the basis, the very thing that triggered all this, still remains. That isn't taken back either. Rather, it always comes down to the way it's presented. To put it simply, I
just want to take a brief moment to provide some additional context here, because now that the official indictment against Vivian Fischer is currently in progress, and there is also a substantial lawsuit for 4.5 million from the Hafen lawyers, she is now publicly admitting to all of this on her Telegram channel. I have also personally archived that specific post for future reference. That she founded a company only with Reiner Fuellmich, she also says with Wolfgang Wodarg, which isn't entirely accurate if what I heard back then is correct. I remember that Wolfgang Wodarg once said at MWGFD that he is involved there as a medical or scientific advisor and otherwise did not co-found it. But be that as it may, even if he had been a co-founder, which apparently was not the case, because Stefan, Professor Homburg, and also Professor Stefan Hockertz were supposed to be involved as well, then I naturally ask myself, first of all, why is Wolfgang Wodarg, Dr. Wolfgang Wodarg, why weren't Professor Homburg and Professor Hockertz called as witnesses? Then one would have known this construct. Or for this construct, Corona Committee precursor or Corona Committee Foundation precursor, GOG, what a name. Terrible, no money was donated at all, because Professor Homburg, I know that he works in the field of, I believe, economics. He definitely would have known, and he could have said so. And these people were explicitly not called, and even the people who were contacted, so that certain questions could be asked. The questions were constantly blocked by the court. The defense attorneys were not allowed to ask certain questions to the witnesses. You really have to imagine that. These were things I just couldn't grasp. I mean, in a criminal trial, strict rules of evidence always apply. At least that's what I've learned from the lawyers I've been working with for years. And when strict rules of evidence apply, then I really have to examine everything. And to me, it seemed as if there was a deliberate intention not to investigate. And for me, this is a political trial. I can't put it any other way, and now I'm curious to see what the Federal Court of Justice will say. And if the Federal Court of Justice now also convicts Reiner Fuellmich in this case, then I will urge my husband, who was also insulted as a professor and civil servant, and publicly so, even by journalists, to take action. I myself have been involved in this case as a journalist. Then we will also reopen the case, because in his situation it was said that as a public figure, he simply has to put up with it. And if judges and prosecutors as public figures and public servants also do not have to put up with this, then that's good. Then you can revive your case now. At least that's how I see it.
Maybe just a brief word about freedom of expression. Of course, freedom of expression is very, very broad, and the Federal Constitutional Court has only recently once again strongly upheld freedom of expression. That's certainly the case. Of course, if someone, in a rush of emotion, says something that the other person might, rightly or wrongly, I don't even want to judge that, perceive as an insult, then it can naturally happen that the other party tries to take legal action. Nevertheless, one must of course also confront how the litigation was conducted here, because the overall circumstances of such a statement must be taken into account. And if you consider the overall circumstances here, and I have been involved for a long time and have seen all the procedural steps that took place, then it is certainly possible, it is entirely possible, for someone to lose their composure. After all, I myself have been working as a lawyer, or at least in a legal capacity, for almost 40 years now. Even I have sometimes had to struggle to maintain my composure, because many things happened there that I would not have thought possible in a normal criminal trial. For example, the fact that everything was only read out in the tabernacle, every motion for evidence that was submitted was completely unknown to the public. And that's why, as the defense, we were even forced, and we agreed among ourselves, to divide up who would read out the motions for evidence in their closing arguments, so that the public would even find out what motions for evidence had been submitted. Even when it came to the verbatim statements of witnesses, these were usually rejected as insignificant or not relevant to the case. So all I can say is that many things that happened there also affected me emotionally at times, and maybe I wouldn't have gone so far as to make such a statement, that's clear. But I too found clear words regarding what formal criteria were completely disregarded in this trial. For example, the issue of signatures. I addressed this very clearly in my last closing argument, but nobody was interested. It was said that there would be a chamber decision on this question of whether the signature, especially that of the presiding judge, is valid or not. They wanted to include that in the verdict, but I couldn't find anything about it in the verdict. So these questions are simply swept under the rug as well, because they might have led to the entire proceedings having to be stopped immediately, since even the arrest warrant, in my opinion at least, does not bear a signature that the Federal Court of Justice could have recognized as such. And that's why I can only say these facts need to be brought to light. And if you don't do that, then the question arises as to how far this is completely contrary to the rule of law requirement for careful conduct of proceedings and the uncovering of all circumstances in such a case. And then you have to ask yourself, is this still a rule of law proceeding? And that's where I am at the moment. And even back then, I already had serious doubts, which, as I said, started with the red notice, issuing an international arrest warrant for a man who would have easily returned to Germany on his own without any question. For me, it's unimaginable to do this over an economic offense in the largest sense, yes, where there wasn't even any damage caused. So it's absolutely absurd what has happened here. It
was.
Sorry, yes, thank you very much. Absolutely absurd.
Yes, as I said, I followed this for a bit longer, and just as an ordinary person back then, I'm a psychologist now, but at the very beginning, when I was still very young, I was also a businesswoman, so I have some knowledge in this area. I also founded 3 companies, so I knew something was off here, and I thought, it can't be that there are 3 lawyers, 2 prosecutors, and 3 judges sitting here. I can't blame the lay judges for this, but 3 judges who really should know that things couldn't possibly have worked this way. I mean, not even Reiner Fuellmich, I think, understood it, because he was the one who drafted the loan agreements as well. That is exactly what Vivian Fischer stated quite clearly during the recent oral hearing, and I later read more about it from Nicole Wolf, that he personally drafted those specific loan agreements with. He wrote, Stiftung Corona-Ausschuss Vorschalt GUG Haftungsbeschränkt as the lender in the loan agreements. And I thought, how could he even do that? How did he even come up with that? There wasn't any money in that account at all. So you could really tell they had no idea what they were doing. I don't know if anyone there had any idea at all, and those who did know that these Corona committee sessions had started much earlier and that founding discussions had taken place long before, including with Professor Homburg and Dr. Hockertz, and that the 2 of them, Vivian Fischer and Reiner Fuellmich, had already established it a long time ago. But apparently they didn't get it either. Now Vivian Fischer probably knows, because she's now writing on her Telegram channel, yes, we were the ones who founded the company and not the other two. So now she's aware of it. Maybe she even read it in your plea. I don't know. But then you really can't accuse them of intent because, sorry, if they were so ignorant, I don't want to say stupid, but if they were so ignorant that they didn't understand anything at all. I mean, along comes a young woman who once did a commercial apprenticeship and says, what kind of nonsense are they actually doing here? What's really going on? And I've also never heard Reiner argue in that direction. He did say at some point, I do remember, when we were sitting in the oral hearing, yes, but I had already founded it earlier with Vivian Pfiffer, so we did found it. He did say that once, but that was it. Absolutely nothing more happened after that. The entire defense strategy went completely off track and fell apart, and that is the reason why I asked you, Edgar, to get involved in this matter. God, what are these lawyers doing? There may have been plenty of criminal lawyers, or perhaps family lawyers, or whatever else, but I honestly couldn't see any, not even a single bit of real expertise in corporate or complex business law. I truly had the distinct feeling that I actually knew quite a bit more about the subject than they ever did. I just couldn't believe it.
One must not forget that even the chamber itself stated that Dr. Reiner Fuellmich had intended to repay this loan from the very beginning, and that no intent to defraud was attributed to him in this regard. So this criminalization with handcuffs and all that, of course, leads to significant protests even among those who are committed, because it's just hard to understand, regardless of whether the conviction was justified in the end or not. But this criminal intent, if you want to put it in quotation marks and in layman's terms, was not present from the beginning. Rather, the money was paid out. It was also supposed to be repaid. You're not allowed to do that either. That's a side note that's included in the verdict. But I think that could perhaps have been taken into account a bit more in the sentencing, or there should have been more consistency there as well. Yes.
Well, let me put it this way. I can't see any evidence of criminal intent at any point in the entire file. What I do see is an incredible amount of ignorance, especially regarding business law and corporate law matters. And I'll just give one example. In the Articles of Association, there is a provision for compulsory redemption. So if a shareholder finds themselves in certain situations, for example, insolvency, their share can be redeemed. But such redemption provisions are only valid if there is also a corresponding compensation arrangement. That is completely missing, and according to the case law of the Federal Court of Justice, such a redemption provision is then void. So it doesn't exist. That alone already shows that such articles of association, which were cobbled together, were made by people who have absolutely no clue about corporate law. This runs like a common thread through this entire issue. In my opinion, there are only two possible corporate law structures. One is the original GBR between Vivian Fischer and Dr. Reiner Fuellmich. That is the Corona Committee. They conducted the investigation, and then there was a second attempt, namely to set up the Corona Committee Foundation through a preliminary non-profit limited liability company, GUG. That failed, and so at the end of the day, there is only one company left, and that is still the GBR between Reiner Fuellmich and Vivian Fischer. Whether it still exists today is another question. Possibly not anymore, but at the time when all of this happened, it definitely existed.
Well, I can say something about that. It's now called, as they themselves wrote on their channel, apparently now called Stiftung Corona Ausschuss GBR.
With the participation of Reiner Fuellmich.
It really has to be the right one.
Money is. How
could it be any different? So, as I said, I myself have founded 3 companies, and it was a mystery to me. I can't just take money out. For example, right now I have 2 companies running. I can't just transfer money from Axiom Resist to the Gießen Academic Society. There was neither a transfer resolution nor a shareholder resolution to transfer the money. There is nothing at all. And that really threw me off, I have to say. No one can tell me that a prosecutor working in this field, so I assume that Prosecutor John has expertise in this area, otherwise he probably wouldn't have been assigned to it. But in any case, that definitely applies to the commercial chamber. And I was just stunned at how something like this could be done. I mean, Manfred once explained to me when he or someone else took action against a judge, I don't even remember who it was, maybe it was a client, that another judge said a judge can just be stupid. They don't have to have committed perversion of justice, they can just be stupid. But no one can tell me that 2 prosecutors and 3 judges are all stupid. I just can't imagine that.
Yeah, neither can I. I can't imagine that either. In this whole story, I see only one truly deliberate act, and that's Templin taking 1.1 million euros. That's the only deliberate act I can identify here, which was clearly carried out to the detriment and harm of Reiner Fuellmich. I can't explain anything else because there were agreements between Reiner Fuellmich and Templin that the loan was issued for that amount in euros. There is a claim for that amount, maybe with a bit of interest on top, but not with the huge amount of interest that was then used to justify taking even more money. That clearly happened deliberately.
And against the background that Reiner Fuellmich has won cases against global corporations, and he was a thorn in the side of the banks the whole time. They wanted him. They didn't want anyone else. Now somehow they can't get around it anymore and want to indict Vivian Fischer. Personally, as I've said in other videos, I believe she hasn't committed any crime either. I actually believe that she hasn't committed any crime either, but now they're pressing charges because it's starting to get strange since it's being talked about in public again and again. And above all, if I may add one more thing, I've read through all the files against Reiner Fuellmich as well. And what did I find? In particular, Antonia Fischer was in constant contact with the prosecutor John, in ongoing contact via emails and so on. And during the oral hearing, she said it's in the records from Nicole Wolf. And Andrea Henning and others have also confirmed this to me. She said during the oral hearing that she had called prosecutor John at least 30 times. But Justus Hoffman also, of course, sent emails to the prosecutor. They basically conducted the investigation, folks. They said, there he is, you can catch him there, we'll lure him here and there, that's how we'll do it. They did that. The prosecutor only had the accounts checked. He didn't have to do anything. They did that, and for me, that's already very questionable for a procedure under the rule of law. And they did the same thing in the indictment against me, I can tell you that. We received the first file back then, we requested it, and it was the same situation. Justus Hoffman and, no, not Viviane Antonia Fischer, said she committed a crime. Look, someone should follow up on that. She said this and that in a video and who knows what else. So once again, they were the ones conducting the investigations. They always do the same thing. They even requested, or rather suggested, that finally something should be done against Katja Wörmer and other people whose names I didn't even know. So they said something. They said something. They basically spoke to this public prosecutor's office, mainly to Prosecutor John at first, and then when they had already taken over the investigations for him, once again, he apparently also told the president of the regional court about it, who, after all, is in charge, essentially already in charge, of the 5th Economic Criminal Chamber. In any case, she said, or rather she wrote, that she was filing the criminal complaint on behalf of the judges, especially on behalf of Judge Schindler. I think as president of the regional court, because she is allowed to do that. So it said something along those lines in there. And it's a completely crazy story that happened there. So these people, they look online to see who is critical. So mainly Justus Hoffman and Antonia Fischer do that. And then they report people to the public prosecutor's office, to Prosecutor John, and he in turn passes the cases on to the public prosecutor's office for hate crimes online. So that's the public prosecutor's office that sued or charged me. That's how it works. They're real informants. I'm sorry, but what else should I call them? Tell me another term if you like. But these seem to be people who are constantly denouncing others to curry favor, and maybe also to distract from themselves, because they had prepared a settlement agreement, or whatever you call it, and wanted to each get a quarter of the money, even though, in my opinion, they had no right to it at all. They were only present at a few committee meetings where they hardly said anything at all. They didn't participate in the planning, they didn't help select the speakers, the door presenters, the scientists. They basically did almost nothing, but they benefited. At least I know of one parents' association that even gave me permission to make this public. I haven't done that yet because I want to protect them myself. A concerned parents' association based in Berlin recently provided me with the official invoice they received from the Hafen lawyers. If I am remembering the details correctly, the total amount they were billed for was well over several thousand euros, covering various professional consultations, legal advice, and other related administrative services. They thought a lawyer would come to advise them, but then all three showed up and all three billed them. And I have this invoice and this information from the Parents Association. The only reason the Hoffman lawyers were contacted was because they had appeared several times at the Corona Committee. That means they benefited greatly from it.
Perhaps I would like to add a final word from my perspective. In all my years, I have hardly ever encountered a case, or to be perfectly honest, I have absolutely never seen a case, where you could so vividly and clearly sense that the primary aim was to systematically and personally dismantle the life of someone who had courageously voiced their dissent and publicly stood in opposition against the state's various measures. It is truly unprecedented. So it wasn't about the matter itself at all, but rather about destroying the person by parading him in handcuffs and leg irons, by cutting him off during the trial, by restricting his defense attorneys, and by limiting public access. They wanted to destroy him personally. And the fact that now there is supposed to be yet another trial about the allegedly embezzled additional euros per month, and that this trial still hasn't even started, just shows me, especially since the first case was dropped and then Judge Schindler had it thrown back at him by the higher regional court, that this is supposed to become a never-ending story. They want to actively stop and prevent this man from continuing to conduct his scientific research, and perhaps carry out further investigations with his old original strength in specific areas that might get even closer to the powerful members of the ruling elite class than what actually happened during the global coronavirus pandemic.
Exactly that.
And they want to prevent that at all costs. That's why they lock the man away. That's why they remove him from Goettingen and the surrounding area, send him to the northernmost border of Germany, where he has no acquaintances, where no one can visit him, in order to simply destroy him personally as well. That is the background of this whole procedure. And all I can say is that is as far removed from the rule of law as we are from the sun at the very least, if not even further. So in my view, it's absolutely unacceptable. But, well, here in Germany, everything gets waved through as soon as it's against someone who doesn't conform to the system. It's as simple as that.
Well, Reiner has an incredible reach, millions of viewers. That's no longer the case with Vivian alone. Now it's just, I don't know, a few hundred people, if that. And that was, of course, enormous because he's well known in the US as well as here. And now on May 5th, I can say this, there will be demonstrations for Reiner's freedom held in 15 countries in front of German embassies. Corresponding letters will also be handed over to the ambassadors there. It is already international and it will remain international. And as long as I say this cannot be a due process of law, I'm even offering Vivian Fischer to testify as a witness for her, confirming that there was previously a GBR. I would do that. The situation is that she wrote to the Berlin Regional Court saying, yes, she is now indicted, but the proceedings haven't even been opened yet. They will also have a problem opening the proceedings, because how are they going to explain that? Because now she herself says, they weren't even involved at all in our first company. So she's actually right about that. She is right, and she has witnesses. She has Wolfgang Wodak, she has Professor Homburg. Stefan Hockertz is now in Switzerland. He also had to flee from the state because things were being falsely attributed to him. Every critic gets crucified here, as we know from Dorothea Thul. And the worst thing I've experienced so far, even worse than with Reiner, is the case against the Prince Royce group. What I'm witnessing there is even more unbelievable. It's incredible. And I have to say, this is unworthy of a so-called constitutional state. I've been very fortunate to have had almost always decent judges. I can't say that I've always encountered decent prosecutors, but I have experienced decent judges so far. I hope that it stays that way. I don't know if it will, but what I experienced in Goettingen, it just left me speechless. And I still remember today how I was shaking when I spoke into the microphone just from being so upset. I had so much adrenaline in my blood, it's hard to imagine.
Well, we're all just human after all.
All right, if you have nothing more to say, then...
Except that I will not be making Ms. Fischer an offer to represent her as her defense attorney. I acted as the legal representative for her business partner, and I painfully felt the absence of her support.
Yes, well, I mean, if the trial comes, but I don't think she'll need me if she invites Professor Homburg and Stefan Hockert and Dr. Wodak, then she actually has enough witnesses who will confirm it because she's right. She founded this company with Reiner Fuellmich and the others. The company never came into existence. They didn't even pay the contributions, not even that. And that's why it was also strange to withdraw shares in the company. And if no compensation was paid to Reiner either, as you say. I mean, all of this, it's all questionable. And then he would still be a shareholder there too. And why wasn't Vivian Fischer admitted as a joint plaintiff? I also don't understand why her lawyer at the time, Frank Rosenbach, I think his name is, why he didn't say during the trial, hey, this can't be right. And of course, above all else, she is. And this is the part that I personally find to be the most interesting aspect of the whole situation. If I have understood the details correctly, Vivian Fischer apparently stated quite clearly that she never actually received the formal invitation to the shareholders' meeting, the very same meeting from which she was ultimately and completely excluded on the 1st of December 2022, supposedly. She didn't even receive the invitation, and I mean the shareholders are obligated to prove that they sent an invitation. Why did neither the prosecutor nor the court check whether all of this was legal? Because I know for a fact, since I actually took the time to check it myself, that it is definitely located in volume 9. I cannot quite remember the exact page number right now, but I am certain that Justus Hoffman personally sent prosecutor John the documents. How was it again? In any case, he wrote to him that, no, that was Antonia Fischer, sorry, my mistake. Antonia Fischer wrote to him that she had been excluded on December 1st, 2022, and he didn't even check whether it was actually legal that she was excluded. That means if it really had been the preliminary GOG, which it wasn't, they would have had to admit her as a joint plaintiff as well, if the prosecutor and the judges didn't know that the investigation had already started with fundraising back in May. If they were unaware of it for some reason, they can still be held accountable for not performing a more thorough and detailed investigation of the matter. That was my closing statement. Thank you all for helping to clarify this, and yes, let's see what else comes next. Thank you. Yes.
There is still a lot more that could be said about this, but we don't want to go into that here because I'm curious to see how the appeal will turn out. At this point, it's only about legal errors, as we all know. The facts are basically clear. They are taken from the verdict, and then it's only about legal errors. There are certainly enough legal errors, but whether the Federal Court of Justice will decide to reopen the case because of them, I don't know. Thank you.
Then there would actually have to be a retrial. How else would it work? I mean, we now know that, at least in terms of substance, the reasoning, whether the errors can actually be punished or not, is questionable. I'm not a lawyer or a legal expert in general, but the reasoning stated in the verdict can't really hold up because there was no preliminary GOG. And actually, the Port lawyers shouldn't have been allowed to appear as victims at all.
Yes, thank you.